Is workplace drug testing legal? Have you ever been asked to take a drug test at work or before even starting a new job and wondered, is this legal? Can an employer really demand a urine test, a saliva swab, or even a hair sample? And what happens if you refuse? The truth is, workplace drug testing is legal in many situations, but the rules are more complicated than most people realize. Federal law, state law, and company policy all play a role. Some industries, like trucking or aviation, are required by federal regulations to test. Others are governed mainly by state rules. Add in issues like medical marijuana or prescription drugs, and the picture gets even more confusing. In this video, we'll break it down clearly. We'll explain what federal law says, how state laws differ, what rights workers have, and real examples of how drug testing has played out. 1. Federal law and mandatory drug testing. Let's start at the top. Federal law. There is no single law that requires all private employers to drug test, but in certain industries, drug testing is mandatory. The Drug-Free Workplace Act of 1988 requires federal contractors and grantees to maintain a drug-free workplace. That doesn't mean every worker is tested, but it does mean employers must take steps to prevent illegal drug use. More importantly, the Department of Transportation, DOT, has strict rules. If we're a truck driver, airline pilot, bus driver, pipeline worker, or railroad employee, federal regulations require testing for drugs and alcohol. These tests happen before hiring, randomly during employment, and after accidents. Refusing is treated the same as failing, so under federal law, DOT-regulated workers must be tested. Federal contractors must maintain drug-free policies. Most private employers are not required but are allowed to test. Example, a truck driver applies for a new job. Federal DOT rules require a pre-employment drug test. If the driver refuses, the employer cannot legally hire them. This shows that in some industries, testing isn't optional. It's the law. 2. State laws and private employers. Outside federally regulated jobs, the rules depend heavily on state law. States set the boundaries for when and how private employers can drug test. Some states allow almost unrestricted testing. For example, in Texas or Florida, employers can require pre-employment and random drug testing as long as they apply the rules fairly. Other states add restrictions. Employers may drug test pre-employment, but random testing of current employees is very limited unless the job involves safety-sensitive duties. Maine and Vermont require employers to have state-approved testing programs with safeguards. Iowa allows random testing, but employers must follow strict written policies and provide rehabilitation options. Marijuana adds another wrinkle. Even though many states have legalized marijuana for medical or recreational use, employers can often still test for it and refuse to hire or fire employees who test positive. The reason is that under federal law, marijuana is still illegal. However, some states, like New York and Nevada, protect workers from discrimination based on off-duty marijuana use. In Nevada, for example, most employers cannot refuse to hire someone just because they test positive for marijuana in a pre-employment test. 3. Worker rights and privacy protections. Now, let's talk about worker rights. Even when testing is legal, employees still have protections. Americans with Disabilities Act, ADA. The ADA does not protect illegal drug use, but it does protect workers who take prescription medications for medical conditions. Employers must be careful not to discriminate against workers legally using prescribed drugs, unless those drugs make the worker unsafe in a safety-sensitive role. Confidentiality. Drug test results are considered medical information. Under federal law, employers must keep them confidential and stored separately from personnel files. Sharing results improperly can violate privacy rights. Due process. Many states require confirmatory testing. For example, if an initial test is positive, a second test, often using a more reliable method like gas chromatography, is required before disciplinary action. Notice: some states require employers to notify workers in advance if they plan to implement drug testing. Others mandate written policies. Example: a warehouse worker tests positive because of a legally prescribed pain medication. Under the ADA, the employer must consider whether a reasonable accommodation is possible. Simply firing the worker without review could lead to a lawsuit. 4. Types of drug testing and when they happen. Employers may use several different types of testing. Pre-employment, often used to screen candidates before hiring. Random testing, conducted without notice, especially in safety-sensitive jobs. Reasonable suspicion testing, triggered when a supervisor observes behavior suggesting drug use. Post-accident testing, after workplace accidents, especially those involving injury or damage. Return-to-duty testing, for workers returning after a drug policy violation. Each type of testing raises its own issues. Random testing, for instance, is controversial because it can feel invasive, but courts often uphold it in dangerous industries. Example: after a forklift accident in a warehouse, the company orders post-accident drug tests for all involved employees. If one worker refuses, the company may treat it as a positive result. Courts have generally allowed this when workplace safety is at stake. Understanding when and how testing can happen helps workers avoid surprises. 5. Real-world examples. Let's look at real stories. Case 1. DOT enforcement. A bus driver in Illinois failed a random drug test. Under federal law, he was immediately removed from duty. He could not return until completing a rehabilitation program and passing return-to-duty testing. Case 2. State restrictions. In Vermont, an employer attempted random testing of office staff. The state ruled it unlawful because the jobs weren't safety-sensitive and the employer hadn't followed required procedures. Case 3. Marijuana in New York. An applicant failed a pre-employment marijuana test. The company rescinded the offer. The worker sued, citing New York's new law protecting off-duty cannabis use. The court sided with the worker. Case 4. ADA protections. A worker tested positive for opioids prescribed after surgery. When the company tried to fire him, he brought an ADA claim. The court required the employer to consider accommodations instead of automatic termination. These cases show how different laws interact and why context is everything. 6. What workers should do. So what steps can workers take to protect themselves? Know your state law. Before applying for jobs or facing a test, understand what your state allows. Review company policy. Employers must often provide written policies about testing. Read them carefully. Disclose prescriptions carefully. If you take medication that could affect results, consider notifying HR confidentially, especially if you're in a safety-sensitive job. Understand your rights. You can request confirmatory testing if you believe a result is wrong. You may also challenge improper testing under state law or the ADA. Seek help if needed. Employment lawyers or worker advocacy groups can provide guidance if your rights are violated. Example: a job applicant in Nevada fails a marijuana test. Knowing state law, he challenges the employer's decision, and the company is forced to reconsider because refusing based solely on marijuana use is illegal there. So the bottom line is this: workers can't stop testing altogether, but we can know our rights and protect ourselves. 7. The bigger picture. Drug testing sits at the intersection of workplace safety, worker privacy, and evolving social attitudes. Employers argue it prevents accidents, protects reputations, and ensures compliance. Workers argue it invades privacy and unfairly penalizes off-duty conduct, especially as more states legalize marijuana. Federal law still treats marijuana as illegal, but public opinion and state laws are shifting. Courts are increasingly balancing safety with fairness. The future will likely bring more state protections and possibly federal reform. For now, the key is awareness. Testing is legal in many situations, but workers have rights. Knowing the rules is the best way to avoid being caught off guard. So, is workplace drug testing legal? The answer is yes, but with limits. Federal law requires testing in safety-sensitive industries like trucking and aviation. State laws set the rules for private employers, with some allowing broad testing and others imposing restrictions. Marijuana laws add complexity, with some states protecting off-duty use. And through the ADA, workers have protections if prescription medications are involved. For workers, the message is simple. Know your state law, know your company's policy, and understand your rights. If something feels off, don't be afraid to ask questions or seek legal advice. If this video helped clarify things, share it with coworkers. The more we know, the better we can protect ourselves at work.